Welcome to News Leader. I'm joined in studio now by Chris Charter. He's the Director of Competition at DLA Cliffe Dekker. Chris, thanks for joining us.
Thanks, sir.
We're going to be talking about the Competition Amendment Act, and it's been in force, was passed since 2009. Just give us an idea of where we are at this present moment.
Okay, so 2009, Competition Amendment Bill passed. Looking down the election year, so probably rushed through a bit quickly on the statute books. Contains quite a few controversial provisions, in particular those relating to criminal liability for people involved in cartel behavior. There's some very strange provisions regarding complex monopolies, which is really just nothing other than being in an industry where there are too few players, and other bits and pieces, one of which is provision for the Commission to formally conduct what would be known as market inquiries. And that's what's just come into force. So only a week or so ago, the President proclaimed that part of the Competition Amendment Act will come into force, and it's that provision. And it's clearly aimed at trying to give the Commission the necessary powers to conduct, for instance, the healthcare industry inquiry. Which
how exactly does it change the ability to do what they need to do?
Okay, previously the Commission had a residual power under Section 21 of the Act, which gave it the ability to conduct sort of advocacy role within the economy. And that means it could look at pretty much anything it wanted to and make recommendations to the Minister, now the Minister of not Trade and Industry anymore, but Economic Affairs and Development. It was a bit loose and a bit broad. The new provisions provide for a specific formal framework for market inquiries. So it gives them formal powers to set a term of reference for a market inquiry, a timeline, invite members of the public to participate, and if those stakeholders don't participate, in fact, to wield their powers of investigation, so they can summons people to appear, they can subpoena documents. So they've really got more formal and I suppose enhanced powers to conduct a market inquiry, which is probably a good thing.
How does this differ? I mean, if we compare ourselves to our international counterparts in terms of competition law, are we still lagging, or does this step take us, that much closer to where they're at?
I don't think we've ever lagged. I think around the world, market inquiries are gaining traction as a way for a competition authority to get a better handle on an industry. Traditionally, you'd need to have some sort of an indication that someone was doing something wrong. Someone was abusing their dominance or fixing prices with a competitor. You would then conduct an investigation. South Africa, like a lot of economies, we have a lot of industries where there are relatively few players. It's quite a transparent industry. For instance, healthcare is a good example. And prices rise, and no one quite knows why. There must be certain economic levers which are allowing prices to rise, or consolidation in industry resulting in less choice for consumers. These market inquiry provisions allow the Commission to investigate and get a handle on exactly what it is that might be distorting competition or in some way restricting competition, without having to say, I know it's company X, Y, or Z that's been doing it.
What about the risk for those companies that don't want to participate in such inquiries?
Well, this is why the provision is quite a powerful one for the Commission. Previously, it was completely voluntary. In other words, it wasn't clear exactly under what powers of investigation the Commission can compel someone to give evidence. So if we look at the banking inquiry of now half a decade ago, it worked quite well, but it depended on sort of voluntary participation. And there you had, 4 or 5 banks, maybe a couple of other stakeholders interacting. And they did it in good spirit. But something like the healthcare industry, there's a lot of players in the various value chains. And not all of them are likely to be entirely cooperative. So the new provisions give the Commission the actual power to say, whether you want to or not, you've got to come and give evidence.
Do you think, from the corporate perspective, do you think this could be challenged in the Constitutional Court?
I think it could be in principle, but I think it would be a bit of a try-on, quite frankly. Market inquiry provisions are a fact of life in a lot of constitutional democracies, the UK being one, Canada being another. So it's not unusual. I think your constitutional grounds would be really based on the fact that it's very broad. But I think if the Commission toes the line properly in setting its term of reference, remember, because it's now a formal process, they've got to go and they've got to publish in the Government Gazette exactly what it is they want to inquire, who's invited, the scope of the inquiry, the timing of the inquiry, so things become a lot more certain. Then I think it's more difficult to try and allege that it's unconstitutional.
Do you see this changing the relationship between business and the powers that be in terms of the law, business law, for example?
I don't think it's completely a game changer. I think the Commission has done very well to insinuate itself into any decent business's sort of corporate governance thinking. You have to take account competition law. So I don't think it's a major change. I think what this does is it provides a framework for the Commission to do slightly more, which is to investigate an entire industry, which perhaps technically it might have found difficult to do legitimately previously. This now make that possible. Business will have to do what it's always been doing, which is take the Commission seriously, interact in good faith, and put its own views across as to how the industry works, hopefully to the benefit of the industry as a whole.
Okay, we're running out of time, but I want to touch very quickly on the proposed investigation into the healthcare sector. What are your thoughts on what sort of precedent that's going to set?
Yeah, I think it's a tough one. I think largely it's driven, I think, by the state's need to ensure that the private healthcare sector can perhaps take up some of the slack the public healthcare sector hasn't really been able to do. And I think perhaps that's driving it more than anything else. But clearly there are concerns about the spiraling costs of healthcare, medical aid fraud. And I think the Commission wants to get a better handle on what the drivers are economically and the influences on price at various levels. So from a medical aid perspective, when you actually go to the hospital, what doctors are charging, the impact of various regulations over the course of the last 10 years or so, and to see what effect that has had. Once they've done that, they can make recommendations, which will be to the Minister of Economic Affairs and Development, suggesting perhaps policy changes. Worst case scenario, or best case scenario, depending on your outlook,
how you look at it,
they uncover some sort of anti-competitive conduct. That may or may not be the case. If they do, then these provisions allow them to simply convert that into a full-blown investigation into a particular firm. So that's the risk for participants, is that if they are doing something which is anti-competitive, they could be on the hook. But it's equally possible that there's a structure here which needs to be amended through policy.
Okay. Chris, we've got about 1 minute. I want to cover 2 quick questions, so you've got 30 seconds for each. Gotcha. The first one is I want your comment on what's happening with the construction cartel. What are your thoughts on that, very quickly?
Yeah, I think that's been a long time in coming. The Commission's been looking at it for several years now, in fact. It's an industry which all over the world has been beset by, perhaps you could say euphemistically, some bad habits. And I think it's going to come to a head fairly shortly once the investigation is complete.
And then lastly, are there any concerns that you have, when you look at South African competition authorities? Any concerns from your perspective?
Quite frankly, I think our competition authorities have done a spectacular job. I think by international standards, they're well regarded in peer reviews. I think like any regulator, there's always a bit of an imbalance between their resources and that of the collective corporate sector. So that's a challenge. But certainly one thing I can say about the Commission is that if the flesh is sometimes weak because of a lack of resources or experience among some of the investigators, certainly the spirit is extremely willing. In the right place, absolutely.
Thank you. We'll leave it there. That is Chris Charter. He is the Director of the Competition Practice at DLA Cliffe Dekker. That's your news leader. Thanks for watching.